Appearances, please.
May it please my lord. S.I. Onoka, I appear for the claimant.
Okay.
May it please this honorable court. My name is Grace Bassey, and my appearance is for the defendant's counterclaimant.
Okay.
My lord, defendant is present.
Claimant counsel, go ahead.
And claimant absent.
What did you say? Claimant present.
Defendant present. Claimant absent. My lord, we apologize for the absence of the claimant, please.
Okay. Okay. All right. So we can go ahead before the network cuts off.
Yes, my lord.
Okay. In the National Industrial Court, Lagos Judicial Division, holding at Lagos, before Honorable Justice Joyce Damachi. Today is the 12th of September 2024. Suit number NICN LA 478-2022 between Crown Flour Mills Limited and Benga Akinyemi. The claimant claims against the defendant as follows. 1, a declaration that the defendant, by the roles he played in the continuation scheme, breached his contract of employment, Olam Code of Conduct 2020 and Olam's policy on anti-bribery and corruption. 2, a declaration that the reversal of the credit notes already posted by the OGBS team to some specific dealers' accounts through the connivance of the defendant and some other ex-employees of the claimant is wrongful, illegal, and unlawful. 3, an order directing the defendant to refund the sum of 20 million naira, which is the total sum received by the defendant under the continuation scheme. General damages for the sum of 30 million naira only in restitution to the claimant following the loss suffered by the defendant in view of the current exchange rate and the cost of action of the suit. The claimant's case. The claimant, Crown Flour Mills Limited, is a subsidiary of Olam International. It manufactures different agricultural products, including but not limited to poultry feeds. Benga Akinyemi, an ex-employee, was a head sales administrative for Crown Flour Mills Limited, employed on the 16th of May 2017, and was bound by the terms of employment contained in his employment letter, Olam Code of Conduct 2020 and Olam's policy on anti-bribery and corruption. 2 years after his employment, in 2019, Crown Flour Mills approved a continuation scheme to boost the sales volume of the poultry feeds. It was initiated by 2 officers in their capacity as National Sales Manager and Business Head of Poultry Feed, Matthew Asu Elimen and Umesh Kane. It was a monthly rebate program on the prices of poultry feeds aimed at encouraging customers to buy more quantities, encouraged by discount. That a number of dealers were selected by the OGBS team of Crown Flour Mills, but in order to defraud the company, Benga Akinyemi, Matthew Asu Elimen, Umesh Kane, and their cohorts decided to focus on 2 dealers, Service Livestock Services Limited and Otis Beauty International Limited. For several months, Benga Akinyemi was instructed by Matthew Asu Elimen and another officer, the Trade Receivables Officer Franklin Adejima, to keep reversing the credit notes initially posted by the OGBS team for the benefit of the company nominated dealers to the accounts of 2 specific dealers. The converted funds were transferred from the 2 dealers' accounts to Umesh Kane through multiple accounts as well as Bitcom's accounts. 2 of the beneficiaries were Rajini Kane, Umesh's wife, and Haris Sharma. In the third quarter of 2021, an insider became aware of the fraud and started blackmailing Matthew Asu Element and Umesh Kane through an internationally generated number via WhatsApp. Matthew Asu Element and Umesh Kane paid 20 million naira using the Bitcoin USSD wallet provided by the blackmailer. Later, he was on a monthly pay of 2 million naira. That on the side, Umesh Kane increased the amount being converted significantly between August sure he deleted the rebate-related mails by Matthew Asu Element. Crown Flowers Mill discovered the fraud on July 29, 2022. The police were invited to investigate the condemnation scheme, and Gbenga Akinyemi was suspended without pay on August 22nd, 2022. That the panel of inquiry set up on September 5th, 2022 found he benefited
I can't hear my lord again.
Hello?
Yes, my lord. We couldn't hear you again.
Hello?
We couldn't hear my lord
Can
again.
you hear me now?
Yes, my lord.
Yes,
Can you hear me now?
Oh,
Yes,
yes,
my
my
lord.
lord.
Okay. So I can go on, right? Crown Flower Mills discovered they were invited to investigate the condonation scheme, and Gbenga Akinyemi was suspended without pay on August 22nd, 2022. That the panel of inquiry set up on September 5th, 2022 found he benefited some money under the condonation scheme. His employment was terminated on October 25th, 2022, and in November 2022, on the 8th of November 2022, he was asked to refund the monies unlawfully received under the condonation scheme. The fraud is estimated between 2 billion and 100 million naira to 3 billion and benefited over 20 million naira. The claimant contract of employment, All Land Code of Conduct of 2022, and All Land's policy on anti-bribery and corruption. The particulars of the breach are that by being guilty of misconduct, there was a breach of trust or any act which is likely to damage the company's interest and reputation by failing to be transparent, honest, and culpable of resisting temptation that might arise in the course of his duty, by not complying with the provisions of All Land Code of Conduct 2022 and All Land's policy on anti-bribery and corruption, which had zero tolerance to bribery and corruption and expected a high level of accuracy in accounting and records in transactions entered into on behalf of the claimant. He therefore contravened the provisions of his contract of employment, All Land Code of Conduct 2022, and All Land's policy on anti-bribery and corruption. The case of the defendant is that the defendant agrees that he was an employee of Crown Flower Mills and worked as a sales executive from 2017 to 2022. He had an impeccable employment record of upward salary review, promotion, award, and general commendation. That he was not bound by All Land Code of Conduct 2022 and All Land's policy on anti-bribery and corruption because he never formed. He averts that there was indeed a training held between 2022 and 2021 in preparation for the introduction of the Code of Conduct, but no such document was ever given to him till his dismissal in October 2022. He further stated that his employer commenced the condonation scheme around June and September 2017 for fish and poultry feed respectively. His job description was to generate sales reports which were used after the commencement of the condonation scheme. In late 2020, he was directed by his supervisor, the National Sales Manager, Matthew Asu Element, to be in charge of the computation of the amount due to each distributor and prepared the reversal files under the scheme. That the actual login to actualize the reversal was done by the trade receivable officer, Mr. Franklin Adejima, who worked at the claimant's Lagos office before he was transferred to the Abuja office. He never received any directive from any senior officer of the company, whether verbal or written, not to obey the directives of the National Sales Manager, Matu Asuelimen, or that the National Sales Manager had no authority to direct him to prepare the credit reverse regime. That on the 4th of August 2022, his employer, without any reasonable ground or justification, commenced a series of unlawful acts of trickery and deceit. Kemi Odi, the HR officer in Lagos, and himself were instructed to leave Lagos to Abuja to carry out inspection of a property in Abuja. He paid for the flight ticket for both of them. On arrival in Abuja, he was interviewed by the General Financial Controller and was made to write statements. He stated specifically that he acted pursuant to the directive of his supervisor, the National Sales Manager, and that at a point he became suspicious of the directive. That they were handed over to the police and driven in a hired cab through the Abuja-Kaduna road from about 5:30 p.m. to about 9:30 p.m. at the time of this illegal arrest on August the 4th in Nigeria. Incidences of banditry, abduction, and kidnapping were rampant by road and by rail from around July 2020 until November 2020. He has stated further that the defendant, that he was kept in custody from the 4th to the 8th of August 2022 when he was charged to court. He was further remanded till the 17th of August 2022 when the police informed the court as follows, and I quote, "The outcome of our investigation necessitates the striking out of the names of the second, in bracket, the defendant/counterclaimant hearing, and the third defendant on the FIR who turned out to be witnesses in our investigation by reason of our finding," and he returned to Lagos. That he returned 2022 pending when investigation is over. The HR manager, Oluwakemi Oni, by email invited him to a meeting on September the 6th, 2022. It was a Microsoft Teams call and an interview. There was no invitation to answer any criminal allegation, and no formal charge was sent detailing any criminal allegation against him before the scheduled interview. The four-man panel found him guilty, notwithstanding the police report which he had exonerated him. He made available to the company every suspicious information which came into his custody regarding the condemnation scheme, but none of these two bodies could trace any kobo to him. That he was dismissed with the effect from October the 26th, 2022. On 8th of November 2022, a letter of demand was sent to him asking for a refund of 20 million naira. His lawyer also wrote a letter of demand dated the 14th of November 2022 to his employers. It was upon receipt of that letter that this suit was instituted against him. He contends that although his letter of employment gives his employer the right to transfer him out of Lagos, every action he took in connection with the condemnation scheme was done in Lagos, not Abuja or Kaduna. His arrest was illegal because he was deceived to travel to Abuja for investigation and thereafter charged, which should have been done by the Lagos State Police Command. He further contends that by telling a lie that he had confessed to committing a crime, the claimant, in bracket his employer, procured his illegal arrest and detention for 14 days on a spurious charge for which there was no prior investigation, but which was at the instigation of his employer. He underwent a needless prosecution for false information.
My lord, I cannot hear you anymore.
Hello?
Yes, my lord, we can hear you now.
Hello?
Yes, my lord, we can
Okay.
hear you now.
So he underwent, okay, good. He underwent a needless persecution upon false information to the police that he had confessed to the commission of criminal offenses and subjected to a wrong jurisdiction of a court for offense purportedly committed in Lagos State. His employer provided the police command, provided no written authority vehicle and driven to Kaduna at night. His case is the accused of the commission of an offense by not sending him to Kaduna by air from Abuja, which was a safer alternative means of transportation. He was maliciously persecuted in Kaduna State on a groundless persecution which could not secure any conviction or sentence. There was no investigation in Lagos State where he worked. Even after being investigated and exonerated by the illegal process, his employers carried out discreet investigation of his bank accounts, mobile telephones, and several interviews. The purported panel of inquiry consisting of members of staff and his employer's lawyers, which alleged he received between 400,000 to 500,000 naira monthly for the reversal, could not prove receipt of any money by him. That the code of conduct or anti-bribery policy documents were never given to him as a result of his unlawful dismissal. At the age of 42, he is unable to take care of himself and his family. Even as a trained IT specialist, he has not secured another employment due to the stigma of dismissal. That he is compelled to counterclaim in order to take the stigma of dismissal away from his employment record after serving for more than 5 years, and he's claiming salary due for the months of August, September, and October, and gratuity for period he worked, and also the time this suit is in court up till the day this suit is decided. And if he is successful, the purported dismissal would be set aside. During trial, the claimant presented 2 witnesses. CW1 tendered 3 exhibits, Exhibit C1 to Exhibit C3. CW2 tendered 9 documents marked as Exhibit C4 to Exhibit C13. The claimant's counsel informed the court that Exhibit C1 and Exhibit C3 were same document and will be relying on Exhibit C3 alone. In the body of the judgment, you have all the listed exhibits. I go ahead. The defendant tendered 14 documents marked as Exhibit D1 to Exhibit D14. I have all that listed in the body of the judgment. I'm not going to read the defendant's final written addresses and the issues for determination. They are all in the judgment. I'll go ahead to the decision of the court.
Yes, my lord.
Your lordship, please.
Okay, the court's decision. I have gone through the processes filed and the arguments of counsel, as well as the testimony of witnesses of both sides. I observed their demeanor during trial, and I would like to firstly correct the defendant's counsel submission in his final address that CW1 testified that he did not prepare Exhibit C1. The records of the court shows that he clearly stated at trial that he prepared Exhibit C3 and submitted it to his line manager. The claimant was employed via the letter dated 17th of May 2017, which is Exhibit C5, and was confirmed on the 16th of November 2017, which is Exhibit D2. It is tried law that an employer-employee relationship is governed by the contract of employment in Amudu versus Amode, citation provided. The claimant is seeking 2 declarations, which will be taken jointly, that the defendant, by the roles he played in the condonation scheme, breached his contract of employment, Olam Code of Conduct 2022, 2020, and Olam's policy on anti-bribery and corruption, and that the reversal of the credit notes already posted by the OGBS team to some specific dealer's account through the connivance of the defendant and some other ex-employees of the claimant is unlawful, is wrongful, illegal, and unlawful. Although much of modern employment law is contained in statutes and statutory instruments, the legal basis of employment, by whatever means, remains the contract of employment between the employer and the employee. Exhibit C5 is a letter of employment and the bedrock of his employment, which may give rise to a common law action for its enforcement or for damages in a case of breach. See IERA versus BFFM Limited, citation provided. Exhibit C5 has embedded a provision that as a staff, and I quote, As a staff of the company, you are expected to be transparent, honest, and capable of resisting any temptation that might come across you in the course of your duty. End of quotation. Was Exhibit C5 binding on the parties? The court in Poly Ida versus Egbeke, citation provided, held that in determining disputes arising from the determination of a contract and meaning, which can be derived from the terms of the contract of service between the parties, which provides for their rights and their obligations. The claimant in paragraph 11 of his statement of fact and paragraph 8 of CW1's witness statement on oath alleged that for several months, on the instruction of Matthew Asu Elimen, the defendant, and one Franklin Adejima, were reversing the credit notes initially posted by the ODBS team meant for the benefit of other dealers to the account of 2 dealers. Defendant testified during cross-examination that he carried out these instructions, hear him and I quote, he sent the schedule via WhatsApp for me to put on Excel and send same for posting, end of quotation. During trial, he said WhatsApp was a formal mode of instrument authorized the use of WhatsApp for official communication. That which has been admitted needs no further proof. He further testified that at some point he became suspicious of the reversal instruction, but did not report his suspicion to anybody because, and I quote, I have no proof of any wrongdoing. The words in Exhibit C5 are crucial claim. Defendant was expected to be transparent, honest, and capable of resisting any temptation that might come across him in the course of his duty. In Imonike versus Union Bank citation provided, the Supreme Court held that words used in the contract of employment are not read strictly in the technical, but are read in the ordinary day-to-day application of the words in the relationship between the parties. Therefore, was Wenga Akinyemi transparent? Was he honest? Did he resist the temptation to reverse credit notes initially posted by the ODBS team for the benefit of 2 dealers against the spirit of the condonation and the provisions of his employment contract? He breached the terms as stated in that contract of employment, I so hold. This brings the court to the issue of the All-Land Code of Conduct 2020 and All-Land's policy on anti-bribery and corruption. Was the defendant bound by these documents? The Supreme Court in Idoni Boye Obu versus NNPC citation provided held that the court has no jurisdiction to interpret or construe contractual documents more favorable to a party outside the terms and conditions provided in the document. Parties are bound by the 4 walls of the contract, and the only duty of the court is to strictly interpret the document that gives rise to the contractual relationship. However, the Court of Appeal in PTE versus WPC Limited citation provided held that a contract may be contained in more than one document. When that is the case, the court is expected to examine all the documents passing between the parties and reach a conclusion from them or from the conduct of the parties, whether they have reached agreement on all material points. Documents relating to contracts of employment must be read as a whole so as to grasp their import. See Chukuma versus SPDC of Nigeria citation provided. In paragraph 5 of the statement of defense, the defendant stated that the 2 documents never formed part of the defendant's terms of employment and were never given to the defendant up till the time he was purportedly dismissed. He stated further that in paragraph 6, that indeed there was a training in preparation to introduce the All-Land Code of Conduct between 2020 to 2021, but no document was given to him despite repeated demands. Under cross-examination, he agreed there was a platform called Workplace, in quote, in the context of the language of the company, and he visited it in the course of his employment. The defendant was, however, elusive to confirm that employees could access company documents, including regulatory documents, and that the All-Land Code of Conduct was in the workplace, even when he was reminded that he was meant to be an outstanding manager who should have known where company regulatory documents were domiciled. From the foregoing, this court is convinced that the defendant was aware of the existence of the All-Land Code of Conduct since 2021, from the training conducted in preparation for its introduction, and the fact that it was placed on the platform, in quote. The fact that he had made repeated demands but was not given one does not mean it never It was never in existence, I so hold. What was the content of the Olam Code of Conduct, Exhibit C12? The defendant under cross-examination read to the hearing of the court section 8, 2, 3, and 4, which is on the key commitments within the Olam Code of Conduct expected from employees. Section B, which clearly spells out zero tolerance culture for any form of bribery and corruption, and basically speaks on integrity and fair play at the heart of all relationships, to act fairly without fear or favor. Section C to E specifies the reporting channel / whistleblowing policy for the employees. Having stated the above, was it bound by the Olam Code of Conduct? If for a moment the court does not think so, it cannot be unmindful of the fact that over the years, the courts have developed rules of law which are automatically implied in the contract of employment unless excluded by statute or express terms of the contract. The three broad duties are duties to obey orders, duty to fidelity, duty of care and skill. Sichioma Care Agomo, Nigerian Employment and Labor Relations Law and Practice, first edition, reprinted in 2012, in page 121, which states that in every contract of employment, a term is implied that the employee will serve the employer in good faith and honesty. He is therefore not supposed to put himself in a position where his personal interest will conflict with that of his employer because he will cause a breach of trust between him and his employer. Lord Esher, Master of the Rolls, said it is impossible to suppose that the master would have put a servant into a confidential position of this kind unless he thought that the servant would be bound to use good faith towards him. See Rob versus Green, citation provided. In Ajayi versus Texaco, citation provided, it was held that sabotage, in other words, there is a term to be implied in the contract of service that each employee will not, in obeying his lawful instruction, seek to obey them in a lawfully unreasonable way, which has the effect of disrupting the system, the efficient running of which he is employed to ensure. See Secretary of State versus ASLEF, citation provided. In the instant case, Benga Akinyemi was employed and he had received commendation, Exhibit D14. He had received upward review of salary, Exhibit D1 and D4, and he was assigned financial roles to carry out on behalf of his employer in a condonation scheme that had received the approval of top management. Did he owe his employer a duty of fidelity? Can the court imply he had a duty to serve his employer faithfully? This is a fundamental obligation, and any conduct inconsistent with that obligation may amount to a breach of contract. Even where the employee undertakes to obey orders permitted by the terms of the contract, it is subject to two qualifications, which will put him in danger. Benga Akinyemi obeyed the instructions of his national sales manager to reverse the credit notes already posted by the OGBS team to two specific dealers' accounts. This, by all standards, constituted a breach of duty by performing an illegal act in the course of obeying a lawful order. In Morris versus Hanley's, citation provided, the court held that if the order is unlawful, he need not obey it. All the court is saying is that the community reading of the Olam Code of Conduct does not depart from the common law rules of implied terms of a contract. However, having examined the conduct and the role of the defendant, he failed in his duty of care and also breached the Olam Code of Conduct. The claimant has been able to prove that the defendant, by the roles he played in the condonation scheme, he breached his contract of employment, Olam Code of Conduct 2020, and Olam's policy on anti-bribery and corruption, and that the reversal of the credit note already posted by the OGBS team to some specific dealers' accounts through the connivance of the defendant is wrongful, illegal, and unlawful. I so hold. Therefore, Relief 1 and Relief 2 succeed. The claimant is seeking an order directing the defendant to refund the sum of 20 million naira which he received under the condonation scheme. Paragraph 17, 18, and 19 of the statement of fact alludes to the panel of inquiry, Exhibit 13, and the police report of Exhibit 6, which is Exhibit 11, which found that the defendant was involved in the fraud by his conduct. The defendant, in his statement of defense, vehemently denied he appeared before a panel of inquiry. He stated that the Microsoft team call did not invite him to answer any criminal allegation against him, and custody regarding the scheme and the two-body school. In his witness statement on oath, said that the claimant putting together the promotion, quarterly discount volume slabs, and several other kinds of schemes run by Umesh Kane and Matthew Asu Elimen. During trial, he tendered Exhibit C3, a computer-generated copy of the Excel sheet detailing the estimated fraud. The police report found that the defendant was not aware of the illegal additional special rebate scheme, but was only used to process and post the special rebates into the distributor's accounts, and were not at any occasion given any share of the proceeds. When asked how and when Exhibit C3 was collected, CW1 said it was after the whistleblower informed the company in 2022, and with the available records in the office, they were able to collect Exhibit C3. CW1 also could not confirm to the court if Exhibit C3 was submitted to the police in the course of its investigation. CW2, in an attempt to establish the amount the defendant benefited, also referred the court to Exhibit C11, paragraph 5.1.18, which found that the defendant received between 400,000 naira and 500,000 naira monthly. All that is before the court is an estimated generated Excel spreadsheet collected after a dubious whistleblower who had himself benefited millions of naira through blackmail had informed the company of the fraud. The leftover data and unsatisfactory available information in the company was used to generate Exhibit C3. The court is mindful of paragraph 12 of CW1's witness statement of oath, where he deposed that Umesh Kane, head of the condemnation scheme and vice president of the company, before his resignation and disappearance, had made sure, and I quote, had made sure the relevant rebate-related mails were deleted by Matthew Asu Elimen, end of quotation. This in itself is clearly speculative. Going by the facts and the testimonies before this court, I do not find any cogent, credible, and reliable evidence in proof of this assertion to grant an order directing the defendant to refund 20 million naira, which is the total sum received by the defendant under the condemnation scheme. This court cannot work with assumption, and neither does the court deal with or dwell on claims based on speculations. See GT versus Okulo, citation provided, Ani Kenta, Best Nigeria Limited versus Rivers State, Attorney General Rivers State, citations all provided, where it was held that speculation has no place in our courts. Accordingly, relief 3 fails. The claimant's fourth relief is for 30 million naira only for general damages in restitution to the claimant following the loss suffered by the business in view of the current exchange rate. In Royok Nigeria Limited versus Attorney General and Commissioner of Justice, Sokoto State, citation provided, the Court of Appeal held per Idris JCA that the grant of general damages is purely discretionary. It is purely within the prerogative of trial court judge who, after considering the entire facts of the case and evidence tendered in proof of same, can decide the sum of money that will be awarded as general damages. However, we all know that the exercise of discretion by every judge must be done judicially and judiciously. The wrong complained in this suit is the heavy financial loss suffered by the company under the condemnation scheme. The defendant, one way or another, contributed to the loss suffered by the company. What the company lost by its conduct cannot be ascertained as stated earlier, that there was a loss occasioned by his conduct. In consideration of the entire facts of this case, and in exercise of my discretion, I make an order as to award the cost of 1 million naira as general damages in favor of the claimant. The defendant filed his counterclaim along with the statement of defense. He sought for the following reliefs. 1, a declaration that the counterclaimant's suspension by letter dated August 19, 2022 is unlawful, null and void. A declaration that the purported dismissal of the counterclaimant by the claimant by a letter dated October the 25th, 2022 is unlawful, null and void. And an order directing that the claimant pay the full salaries and other entitlements of the counterclaimant from the 1st of August 2022 until this suit is determined at the rate of 353,000 naira 950 naira 10 kobo. He's also seeking for a relief of 100 million naira as damages for false imprisonment of the counter-claimant by the claimant at the Gabasawa Police Cell, Kaduna, from August 4 till August 17, 2022. He's seeking for 100 million naira as damages for the malicious prosecution of the counter-claimant from August 8 till August 17, 2022 at the Kaduna Magistrate Court, and seeking for 200 million naira as damages for the endangerment of the life of the counter-claimant by the claimant on August 4, 2022, when the claimant procured the illegal arrest of the defendant and made the defendant to be taken along the Abuja-Kaduna highway at night, arriving in Kaduna about 9:30 p.m. He is seeking for 15 million naira, being the legal cost of the defense and counterclaim filed by the defendant in the suit, and also 151,000 naira being the ticket cost for the flight of the counterclaimant and one Oluwakemi Oni to Abuja on August 4, 2022, and another directing that the gratuity of the counterclaimant be calculated at the conclusion of this suit and the sum due paid to the defendant. On relief A, the defendant / counterclaimant has argued that he cannot be suspended without pay pending investigation. The suspension was based on an allegation of breach of the Olam Code of Conduct after the police report had exonerated him in unreported suit between Edwin Ezechukwu versus OHHA /2020, delivered on the 21st segment, stated that the modern jurisprudence has ushered in by the Third Alteration Act is that suspension without pay pending investigation is set in the terms and conditions of employment. The learned jurist went further to state that cheating on contract is very explicit on this. There is no implied contractual right on the part of the employer to suspend without pay on disciplinary grounds. For there to be no pay, it must be expressly stated in the contract agreement of the parties from his favor that he had a right to his salaries during suspension until it's shown that there was a term of the contract that provides otherwise. And proof in this respect must come from the defendant who claimed there is by tendering the terms and the conditions of service and showing where that right is. Right to salary is the most fundamental right in the employment contract, as it is the consideration for which the employee enters into the contract, and as such, physically. This is what the Court of Appeal, when it stated, an employee whose employment has not been terminated is entitled to his salary and emolument. It simply means without anchor for it in the employment contract, the employer cannot unilaterally impose suspension without pay in the suspension letter. In the instant case, Crown Flour Mills, in its offer letter Exhibit D6, did not provide for disciplinary procedures. However, in Exhibit C12, Olam Code of Conduct in section A3, I quote, "What is expected of you?" Bullet number 5 reads, and I quote again, "To be contravening the code will face disciplinary action and could lose their job." End of quotation. Collins English Dictionary defines disciplinary action as punishment of some kind meted out to a member of a profession or organization who has committed a breach of the Code of Conduct, ECT. While the Cambridge Business English Dictionary defines it as a method for dealing with a worker who causes problem or does not obey company rules. It is clear that both documents which were tendered did not provide for suspension or disciplinary action without pay. To creatively brush aside the right of employee to his salaries by casually stating so in the suspension letter without any prior anchor in the employment contract is a fundamental breach of the contract. In view of the above, this court is satisfied that the defendant's suspension without pay was unlawful. He is therefore entitled to his pay during the period of suspension, 19th of August 2022 to October the 26th, 2022. I so hold. On relief B, the defendant's counterclaimant had argued that his dismissal by a letter dated October 25th, 2022 is unlawful, null and void. Due to the criminal nature of the allegation to which he had been exonerated, the law is that once an employee is dismissed, that employer must justify the dismissal. The duty to justify the dismissal lies on the employer's argument that the termination of the claimant's employment was as a result of the breach of the Alarm Code of Conduct. This explanation of breach of the provisions of the Alarm Code of Conduct, such as Section B 2 sub 3, 2. Claimant as dismissal connotes gross misconduct. Held that by the role the counterclaimant played in the condonation scheme, the claimant's letter of dismissal was lawful. In unrepeated suit number NICS/ABJ/28/2020 between Mohammed Hamza versus Dangote Flour Mills before Honorable Justice Oyewumi, now JCA, delivered on the 22nd of February 2022, CBN versus Dine 2021 15 Nigerian Weekly Law Report Part 1795, which was referred to, and I quote, the apex court held that when there is an allegation of misconduct amounting to crime against an employee, before dismissal of such an employee, he should be tried and convicted by the court, as it is the court that is vested with this. It is beyond the power of an administrative panel to try and convict such a person. In the instant case, the claimant was accused of stealing bags of wheat, which is a criminal offense. Thus, he was rightly reported to the police and subsequently tried in a court of law. The defendants could have been wrong if they, without criminal trials, assumed jurisdiction over sin. The pertinent question that should be asked in this case is, what will happen in the event that an employee is discharged? But put differently, can the discharge of the claimant on a no-case submission stop the defendants from terminating his employment? In other words, are the defendants obligated to reinstate the claimant after the discharge of a no-case submission? I do not think so. In the case of Joe versus Okitipopa Oil Palm PLC citation provided, the court held that the discharge of an accused person, of an accused employee on a no-case submission may not necessarily stop an employer from terminating his appointment or dismissing the employee if the employer comes to the conclusion that there is more to the whole matter than the criminal prosecution and the subsequent. With a principle that in a master servant employment, as in this instance, an employee, even though willing, cannot be foisted on an unwilling employer. Thus, an employer may still discharge on a no-case submission where it comes to the conclusion that there was more to the whole case than the discharge. This case is equally convinced that the dismissal of the defendant/counterclaimant was lawful. By Exhibit D6, the offer letter tendered by the claimant has embedded in it the procedure for termination after confirmation. Part B is sub 2, and I quote, by the company without notice or payment in lieu of notice in the event of serious misconduct, end of quotation. The police report exonerated Benga Akinyemi of the criminal charges, but his employer had a right to dismiss him from the employment, I so hold. On Relief C, the court recalls that in Relief A, it was resolved that the defendant is entitled to his pay during suspension. This follows that he is to be paid his full salaries and other entitlements from the date of his suspension until the effective date of his dismissal. Relief C succeeds. On Relief D, E, and F, for 100 million naira as damages for false imprisonment from August 4th till August 17, 2022, and 100 million naira as damages for the malicious persecution, and 200 million as damages for endangering his life on August 4th, 2022, along the Abuja-Kaduna Highway at night, arriving in Kaduna at 9:30 p.m. In Oyedima versus Nite, citation provided, the Court of Appeal held false imprisonment to mean imprisoning or restraining or detaining a person falsely or unlawfully or wrongfully. If the person doing or causing the imprisonment has the right to do so, then the imprisonment cannot be false or unlawful or wrongful. An action for false imprisonment does not lie only against a party who physically commits the crime. An action lies against a party who is directly or actively instrumental to the commission of the tort. Therefore, to succeed in an action for false imprisonment, the plaintiff must show that it was the defendant who was actively instrumental in setting the law in motion against him. See Mandilas versus Apena, 1969, Nigeria Wiki Law Report, citation provided. So in the instant case, the arrest and subsequent detention of the defendant by the Nigerian police in the cell in Kaduna are facts not in dispute. The report by Vinod Kumar, as testified by CW2, set the law in motion against the defendant. The parties did not present to this court the reason why bail application was not granted after the first sitting on the 8th of August, and the matter was subsequently adjourned to the 18th of an assumption on why the defendant was denied bail. It is not the judicial function of a judge to embark on an unguarded of discovering for facts which are not placed before it. Toby Jesse, Ajikawo versus Ansaldo Nigeria Limited, as held provided. If the person doing or causing cannot be false, unlawful, or wrongful, I so hold. Therefore, relief D fails. Malicious persecution is a civil wrong which enables a person who is the subject of groundless and unjustified court prosecution proceedings to seek a civil claim for damages against the prosecutor. The question to my mind is, was Olugbenga Akinyemi maliciously prosecuted by his employers without reasonable and probable cause? And was he given a fair hearing? In other words, was there a reasonable ground for the complaint made against the defendant? He asserted via paragraphs of his pleadings that the employer set the law in motion against him, which resulted in his eventual prosecution before a magistrate court, but which proceedings ended in his favor. Defendant, in his witness statement on oath, stated that when informed of the fraud in Abuja, he was asked to write a statement, which he did, and stated all he knew about the condemnation scheme and how at some point he got suspicious of the instructions from the W2 under cross-examination, testified, lodged the complaint at the police station on the 3rd of August 2022, following the fraud alert by the whistleblower. The court is mindful that there were unchallenged facts that all the details of the condemnation scheme details had been deleted by Umesh King before his resignation and disappearance into thin air. From a careful consideration of the facts and evidence on record, there was an honest belief by the claimant which cannot constitute malice. The claimant was left with no choice but to lay the complaint at the police station, which is the only institution with a mandate. The information about the fraud was reasonable grounds on the part of the claimants to make a complaint before the police. The claimant/defendant, Crown Flour Mills, on their part, via paragraphs 9 and 10 of their statement of defense to the counterclaim, and paragraph 2D, say the investigation and prosecution was entirely driven by the police. Thus, upon the conclusion of the investigation, the police preferred a charge against the defendant/counterclaimant based on the independent investigation conducted by the police for the actions of the IPO and other officers of the Nigerian Police Force. Besides, in Fawemini versus Akilu, citation provided, the Supreme Court held that the law of Nigeria has given every person a right to prevent the commission of a criminal offense, and where an offense is committed, to lay a criminal charge against anyone who has committed the offense in order to uproot crime from the Nigerian society. In the case of John Holt PLC versus Allen, citation provided, the court held that a reasonable and genuine complaint made bona fide to the police that a crime has been committed cannot ground an action for malicious prosecution. In the absence of malice and lack of reasonable cause on the part of the claimant defendant to counterclaim, I am of the view that the case of the defendant counterclaim on malicious prosecution cannot succeed without the proof of malice against the defendant. From the facts, the exhibit standard, and the testimonies before this court, the claimant/defendant has been able to show that the company, Crown Flour Mills, had reasonable and probable cause to make the complaint to the police. I so hold, thus relief E fails. Was the life of the defendant slash counter-claimant endangered on the 4th of August 2020 arrived in Kaduna at 9:30 p.m. The testimony of CW2 that she has traveled the Abuja-Kaduna road severally, and particularly in 2022, and it was notorious for banditry and kidnapping. And there was also police patrol on that road is enough testimony about the notoriety of that route. The claimant argued that they only laid a complaint to the police, and the way and manner the police went about their investigation was not part of their instruction. The court is not convinced that they had no idea how the defendant arrived in Kaduna. The court therefore failed in its duty of care to protect the life of an employee on that fateful day. Relief F succeeds and award the cost of 100,000 naira only as damages I so hold. Relief G is for cost of litigation of 15 million naira only. This relief, which is in the nature of special damages, is expected to be specially pleaded and proved strictly. Also, see Chief Olushola Ogunshola and another versus Mr. Blaze, citation provided, where the appellate court held at pages 20 to 21, paragraph F and D of the report that the appellant had also claimed the sum of 500,000 being the sum expended by them as legal fees in suit number ID/732M/206 in regaining possession of the property in issue, and a sum of 750,000 being cost of this action. The lower court rightly surmised that these claims were in the nature of special damages, which must be specifically pleaded, itemized, and strictly proved before being awarded by the court. See Oniora versus Oniora, citation provided. I've gone through the entirety of the defendant/counterclaimant's pleadings and the witness statement on oath of DW1, and not seen where this 15 million naira has been specifically pleaded, itemized, and strictly proven. Cost of legal representation incurred by one party is not recoverable from another, as that would be unethical and constitute an affront on public policy. See Guinness Nigeria versus Woko, citation provided. Having not specifically pleaded and testified with respect to this claim, I'm of the considered view that defendant/counterclaimant has not satisfied the requirement of proof in the circumstance. Relief G is therefore refused for want of proof. With respect to Relief H being a claim of 155,000 naira for the cost of flight ticket for the counterclaimant and one Oluwakemi Oni to Abuja on the 4th of August 2022, the claimants have denied it gave instruction or approval to the defendant's counterclaimant to buy the ticket. During cross-examination, the defendant was asked if he got approval to pay for the tickets, and he said there was no approval for him to buy tickets from his personal to the office for the funds and was awaiting approval before purchasing the tickets. Defendant/counterclaimant assumed that he would be refunded, and he bought 2 plane tickets without applying for and getting approval. In this circumstance, the court is constrained to dismiss this Relief H, and it fails. Relief I is an order for gratuity of the counterclaimant to be calculated at the conclusion of this suit and the sum due paid to the defendant. Claim caught up by the special rules made in that regard. The burden of proving entitlement to gratuity benefit rests on the defendant/counterclaimant. He led no evidence to prove that his contract provided for payment of gratuity. There is nowhere in the exhibit standard that a provision is made for payment of gratuity. The right to gratuity is not automatic, and it's dependent on the contract of employment and the conditions of service. Relief I therefore fails for lack of proof. In all, the claimant's case succeeds only in part accordingly, and for avoidance of doubt, it is declared that the dismissal of the defendant's employment by the claimant is legal and lawful. Relief A and B succeed. In order that the defendant shall, it is ordered that the defendant shall pay within 30 days of this judgment to the claimant the sum of 1 million naira only, being general damages. It is also ordered that the defendant is entitled to his pay from the date of suspension until the date of dismissal. That to the tune of 100,000 naira only. That relieves D, E, G, H, I all fail. Failure to pay these sums as ordered means that the sum shall attract 10% simple interest per annum until fully paid. Judgment is entered accordingly, and I make no order as to cause. Signed by Honorable Justice Joyce Damachi. So this is the judgment of the court. Hello?
My Lord, I'm grateful for this well-considered judgment. It's also intellectually enlightening.
Okay.
Yes, my Lord, we are grateful for the judgment.
You're welcome. Okay. Thank you. Have a good day. The registrars.
Have a good day,
The
my Lord.
registrars.
Hello, ma.
Okay, have a good day too. Okay.
Hello, my lord.
Okay.
Hello, my lord.
My Lord, the registrars are answering you.
Okay, yeah, I can hear them. I'm trying to leave the meeting.
As a call, please.
Okay.
Hello, Ibro.